Hello, welcome to today's episode of the Law Show, where we talk about law without fear or favor. Now, we did 2 episodes on the Land Use Act and its impact on traditional land ownership, particularly in Benin Kingdom. So the first one, we talked about whether or not it is correct that all individual, family, community ownership of land had been abolished. And then the second one, we talked about the relationship, the post 1978 Land Use Act relationship between the Israel Majesty, the Oba of Benin, and land. And I postulated that the Oba continued to retain relevance in land transactions in Benin Kingdom. So questions arose from viewers who had watched some of the shows. They asked questions here and there. Some were difficult questions, some were downright simple questions. So we just did like a potpourri. We just chose some questions. And I've got with me here in the studio to ask me some of the questions. Say hello.
Hello.
So this is Josephine Ogagaworia. Josephine is a law student from the Ambrosali University who is on internship with Dele Igbinedion Chambers. But beyond that, fear her, because she's a judge in the court, in the students' court. What's the court called? What's the name of the court?
Oh, the Student Union Government High Court of Ambrosali University.
That's Students Union Government High Court of Ambrosali. So we can actually call you your lordship, right?
Yes.
Your lordship, your student
Correct.
lordship. Okay. All right. So your student lordship, you are welcome.
Thank you very much.
Ask to the Law Show.
All right. Hello, everyone. It's good to be on the show today. Okay, so we'll be taking questions of our viewers. So far, we selected a few questions. I hope you're ready to answer them.
I'm ready, if you are ready.
All right. First off, the topic for today is, what is the legal status of community land allocation documents in Edo State? And so on that ground, we have several questions that require answers. Okay, since 1978, this is the first question. Since 1978, it is arguable that the land tenure practices of the Beninese changed somewhat, with transfer of lands taking place without specific recourse to the Oba of Benin. So what is your opinion on this matter?
Take the question again. Since 1978?
That's
yes.
Since when the Land Use Act was
promulgated,
commenced,
yes.
So it is arguable that the land tenure practices of Benin changed somewhat,
yes,
with transfer of lands taking place without specific recourse to the Oba of Benin. People don't ask for the Oba of Benin's approval or opinion anymore. So what's your opinion on that?
Well, Josephine, I'm going to say that I think it's illegal.
Okay.
I think it's against...
illegal, strong word.
Somewhat, yes, somewhat is changed, because right here I have like one of the community allocation documents issued by a community. Through the Land Allocation Committee, they wrote to the Odionwere application for allocation of building plots. So this gentleman was allocated 100 by 100, signed by the Odionweres and elders. So there are two angles to it. The first angle is, if these transactions are done without reference at all to the Oba, it will be wrong. But if they are done with reference to the Oba, either express or implied consent of the Oba, okay, then it will be right. Okay, so there's a middle way.
Even after the
Land Use Act.
Yes.
Now, prior to the Land Use Act, we have another document here where all that the Israel Majesty would need to do was to write approved. Just approved and sign it and date it. So that used to be how it was done. There were wards. Benin was divided into wards, and each ward had its land allocation committee. But the procedure for acquiring land was still threefold prior to the Land Use Act. Threefold. One, you had to go to the person who was the farmer or landholder or the owner of the land. You had to pay for it. Okay. In other words, because you are going to apply for Oba's approval did not mean that you didn't have to buy the land. So you still have to go meet the owner, pay him whatever. In those days it was either guineas, you have to pay in guineas or cowries or kobo when it came, and then naira and kobo, whatever. So you have to pay for it. Then you approach the community land allocation committee, and their role really was to go and inspect and ensure that it was free from dispute, because the Oba trusted them, okay. Like delegated authority to them to look at it, ensure that there's no dispute, and they recommend to His Royal Majesty that, Your Majesty, the thing is dispute free, and they will write it on the paper, say recommended for approval, plot inspected, no dispute. So that's their role. Then the third one is now for His Royal Majesty to write approved on it. It's a matter for His Royal Majesty whether he decides to be writing approved or how he wants to do it, or he gives his consent tacitly. I mean, people could approach him in his palace and say, okay, go ahead, I don't have a problem with it. Really and truly, it's for the Oba to either say, I did not grant approval for this particular transaction, or I granted approval for this particular transaction. Okay. But the prima facie evidence of his consent is writing the words approved. Now, the question is, when people do transactions without reference to the Oba at all, that will mean that whoever has acquired a title in that property would have acquired not a legal title, but an equitable title.
Okay.
Yes.
Even after obtaining perhaps a certificate of occupancy. Even
if he gets, and this is where it becomes interesting, Before Land Use Act, the legal title of all lands in Benin Kingdom was vested in the Oba.
Yes.
And there's no dispute about that.
No dispute.
But the Oba was not acting alone. In other words, like I said earlier, it's a three-stage process. You buy the land, you approve the land allocation committee, then you go to the Oba for approval.
Okay.
Now, if somebody buys the land, you've done the first step. You obviously approach the allocation people who give you this document. You've only done two. Then you sort of frog leap over His Royal Majesty, and go to the ministry and say, give me a certificate of occupancy. And they give you a certificate of occupancy. In my humble opinion, what the person has is still an equitable title.
Okay.
Why do I say that? It's not a legal interest. Why do I say that? If you have a certificate of occupancy that is not backed up by fulfillment of the conditions precedent, the courts can still nullify it. And we have many that the courts nullified. There have been many the courts have nullified. The only document the courts have never been able to nullify is the Oba's approval. But
never. There's no case.
Never. No case. To my knowledge. Now, my knowledge of the law is very small, as you know. I've only read a little bit of law. There are those who have read a lot more than I do. So if you are watching and you have a case where a court nullified an Oba's approval, by all means, unless it was proved that that approval was not issued by the Oba, in other words, it was forged or fake, then the court can say this is fake and, I nullify it. And nobody will quarrel, not even the Oba. But in cases where it's been established that the Oba issued approval, even if you issued more than one, none is nullified. The court will only say, well, the first in time will prevail.
Of course.
So my answer, straight answer is, any land transaction that is done without the either actual or ostensible approval of the Oba is still only conveys an equitable interest.
Okay. And not a legal interest.
And not a legal interest.
All right. Thank you very much for that.
Do I need to explain what's an equitable and legal interest? Or
for the sake of our viewers,
understand it?
I believe we might have viewers that are not, inclined in law. They are not law students or lawyers per
Yeah,
se.
you should go and get a lawyer.
So they might want to know what a legal interest is or an equitable interest. You can just throw more light on that, like briefly, what an equitable interest is and what a legal interest is. So.
Well, the legal interest, if I might just say it in a layman's language,
Okay.
you know, without going to technicalities of the law, is there are two kinds of interest you can have in land. When you have complied with all the strict formalities of the law, you know, the law prescribes formalities for, you know, for you to,
Obtain land.
for example, if you want to get married, there are formalities for getting married. You go and pay the bride price, you visit the parents, they do that, they give consent, then, you know, they take her to your house, you have married her. That you have a legal interest, okay? Okay, so you've done all the procedure. But if you skip one procedure, you didn't, you went to visit the parents, but you actually didn't pay any bride price, and the girl followed you home and you started having babies. So she's your common law wife, but you have an equitable interest, you know, there's still something missing you haven't done. So that's akin to acquisition of land. If, for example, you know, the land is supposed to be sold for you at 500,000 naira. You paid 350. You didn't pay complete. You don't have a legal interest. You have an equitable interest because you haven't fulfilled the procedure.
But you do have an interest.
You have an interest. The law recognizes you have some interest.
Okay.
So that like, shall I use the word, that interest that is not full is what we lawyers call equitable interest. The one that is complete is what we call legal interest. So your interest is complete. There's nothing else you need to do. You've done all the formalities.
But it's actually possible for someone to not have any interest at all.
Yes.
If you've not done anything.
If you've not done anything, you don't have any interest at all.
Yes.
Or if you've done everything wrong, you don't have any interest at all.
Everything wrong.
Everything wrong. So you must have done some things right.
Yes.
For example, if you only paid the guy on the land, you have an equitable interest. You have something the law can protect. You know, there was a case where, you know, even though, you know, the land owner, quote and unquote, his lease had expired. He had a colonial lease which had expired, but he had land, he had buildings on the land, and his opponent went to get a certificate of occupancy from the governor.
Okay.
The court said no. This guy, even though his lease has expired, he has land, he has buildings on the land. Those buildings constitute equitable interest. And that interest is taller than the certificate of occupancy issued by the governor. It's taller, stronger. So I have always advocated that the certificate of occupancy is issued by governor, pursuant to the Land Use Act, are actually worthless documents if you do not have the title to the land. If you didn't acquire it, you haven't done the proper thing. It's useless.
But then if you have done the proper thing and then you don't obtain the certificate of occupancy,
you still have interest. You have equitable interest, which no other person can take from you.
So in other words, to have a legal interest, you must have done the formalities, that's the requirements of the law, as well as obtain this the certificate of occupancy.
Yes.
That's the only way to get a legal.
That's the only way to get a legal interest.
All right. Okay. So I hope the viewers are following, and we'll be moving on to the next question.
If they are not following, they can send. We can ask more questions.
Okay. Another
Right.
question from another viewer. It says, it is often believed that the Land Use Act revolutionized the land tenure system in Nigeria and made the governor of the state and local government chairman the sole grantors of interests in land in Nigeria, with all pre-existing grantors abolished. Is this correct? Let me go again for my question.
Yes.
It is often believed that
the
Land Use Act
yes,
revolutionized the land tenure system in Nigeria.
Okay.
And made the governor of the states and the local government chairman the sole grantors of interest in land in Nigeria, and abolished all pre-existing grantors of land in Nigeria. Is this correct?
This is not correct.
Okay.
The Land Use Act did not abolish anything. in actual fact. It did not abolish all pre-existing grantors. There is no section of it. I have a copy of it here. One produced by Princeton Publishing Company. It's about 51 sections. 51. Am I right? 52. Okay, the last one says this act may be cited as Land Use Act. That's the last section. 52 sections of it. None of it says we hereby abolish, anything. So what the law does not expressly say, you can't read it into it.
Okay.
And there's a school of thought, and there are some decisions that have held that, the Land Use Act abolished, everything, and this was the attitude of the Supreme Court from the beginning. When the Land Use Act came in, everybody was trying to understand it. You had earlier decisions like Savannah Bank and Ajilo, and some others where it said, look, either you comply strictly or you have nothing. It's all or nothing, and they were nullifying. But since then, the Supreme Court and the appeal courts have moved away from that interpretation, so that they understand now that when the Land Use Act came into effect, Section 34 preserved all pre-existing interests, all pre-existing rights. It preserved their title. The only thing is it transmuted that title into a deemed grant, as if the governor had given them a statutory right of occupancy. And this is where I have issues with people who say that the interest of the Oba was abolished. There was a judgment where it said that maybe I can just read it so that I can quote it exactly. I don't want to mislead. It says, before the Land Use Act 1978, land in Benin was vested in the Oba of Benin, who held same in trust for the common good of all. You can't oppose that. That's a good statement of law. Then it says, since the coming into effect of the Land Use Act, the Oba of Benin ceased, as in stopped, to be the custodian of land in Benin.
Do you mind, for the benefit of the viewers, just say the authority, like the case, so those that want to maybe confirm this judgment, because you are reading from yours, and they might want to confirm that is what the court actually said. So you just say the case,
Okay, it's a decision of the High Court of Benin City, High Court of Edo State, sitting at Benin. It's I hope I won't be okay. It's Frank Agbongiato, suing through his lawful attorney Ilofuan B. Igboan and Mr. Faith Morris Akolo, something like that. Okay. So that's the decision. It says it is ridiculous to think that what the law took away from the Oba of Benin in this case was now vested in the Ohen Ige and elders of Ikweniro village. In other words, two things come out here, or three things. One, before the Land Use Act, land in Benin was vested in the Oba.
Yes.
Since the Land Use Act came in, the Oba stopped being the custodian of land in Benin. And three, since the Oba stopped, the elders and the...
By implication, stopped.
Also stopped.
Yes.
And only the governor could give land. So, question is, if you now want my land, if you want to buy my land, you, Josephine, you want to buy my land.
Okay.
You go to the governor and you come to me and knock on my door and say, good morning, sir. I'm now the new owner of your land. See, governor has given me certificate of occupancy over your land. What do you think I'm going to do as a typical Igbake man? Meaning I will sharpen my cutlass. What do you think? So the governor will give you certificate over my land?
You give what you don't have.
You cannot give what you don't have. Now, let me also, when talking about this, let it be clear that I have the utmost respect for the judge. I have the utmost respect for every judge. I have the utmost respect for my colleague lawyers. I have the utmost respect for law students. I have utmost respect for law thinkers, But this is just my opinion. It's just my opinion. So if you have your opinion, also say your own. Don't go around, saying that Dele said. You say your own so that we can also listen to your own. But this is my opinion, Josephine. Yes. My opinion is this. Before the Land Use Act, the Oba was a custodian not just of the land. He was also the custodian of the native laws and customs of the Benin, right?
Right.
On any question of interpretation of the custom of the Benin,
Right.
by the traditional rulers and chiefs law, he is the prescribed authority that will say, look, this is the custom. Okay. So now, land of a people is intricately linked to their custom. The land tenure system is intricately linked to the custom of the people. In other words, the way the Urhobos, and I think you look like Urhobos, okay? The way the Urhobos do transfer of land is not the way we Igbanka people do transfer of land. It's certainly not the way the people from Umogunokwa do transfer of land. So, it's not the way the Yorubas do transfer of land. If I come to I don't know, to Uroboland now and start asking for the Bale, they will ask me who is a Bale. They won't know who is a Bale. But if I ask for the OVA, they may understand what I mean. So each have, their ways. Now, question is, if the Oba remained after Land Use Act the custodian of the native laws and customs of the people, how can he lose being the custodian of land? And what section says he loses the custodian of land? I can't find it here. Now, again, I'm a law student for life, so I'm quite amenable to being educated by any person who has. But the transitional provisions, section 34, subsection 1 says, the following provisions of this section shall have effect in respect of land in an urban area vested in any person immediately before the commencement of this act. Now, the entirety of the Benin Kingdom, not Benin Kingdom, Benin City area, by the designation of urban areas order 1987, was made an urban area. 15 kilometers radius starting from the King Square, from the what we call the popular ring road. 15 kilometers radius around the ring road constituted an urban area. So that is by the urban area designation order. So if that area was an urban area, and this law says the following provisions of this section shall have effect in respect of land in an urban area vested in any person immediately before the commencement of this act. So the question to ask is, in whom was the land vested before this law commenced, so that we can know whether this section applies to that person or not. Now we have the case of Gold and Osarere. Gold and Osarere says that this is page 15 of Gold and Osarere, Supreme Court decision, Gold versus Osarere. I'm sure it's a popular decision, 1970. All land in Benin is owned by the community, for whom the Oba of Benin holds the land in trust. And it is the Oba who can transfer to any individual the ownership of such land. And until so transferred, the occupier may continue to hold it for purposes of farming only. Okay, there's some place I needed to read out. Sorry. I needed to read out. The entire case, which was this Gold and Osarere, proceeded on the basis that the radical title to all Benin lands rested, use the word rested, in the Oba of Benin. I think what they wanted to say is vested in the Oba of Benin. Okay, so if we agree, and I'm sure if you are watching this, you agree with me that prior to 1978, all lands in Benin, the title vested in the Oba. So section 34 says, the following provisions of this section shall have effect in respect of land in an urban area. So using Gold and Osarere, let us say vested in the Oba of Benin. Let's just impute it like we are taught in church. They say if you want to claim a blessing, put your name inside the Bible verse. Okay, so it says the following provisions of this section shall have effect in respect of land in an urban area vested in the Oba of Benin immediately before the commencement of this act. Okay, where the land is developed, the land shall continue to be held by the Oba of Benin immediately before the commencement of this act, as if the Oba was the holder of a statutory right of occupancy issued by the governor under this act. In other words, before the Land Use Act, the land, assuming this is the land, let's assume this is the land, was vested. Let's assume I am the Oba. Tell me, Oba. Okay. So this is the land. This is vested in the Oba. So the Land Use Act. You are the Land Use Act. Shake my hand. Land Use Act. You are welcome. Section 34(1) says, 1 and 2 says, after you shake my hand, the land will continue to be vested in me, as if you granted me a statutory right of occupancy. You didn't want to leave my hand again. Okay, so where then did it say that, you know, the interests of the Oba
has been abolished?
Has been abolished? And I think that there was some panicky interpretation of the Land Use Act, because it was a military government. They brought it in. People were panicking. You know, judges respectfully were giving interpretations. Scholars were writing all kinds of things, and there was some stream of interpretation. Let me put it like that, respectfully, which has since been corrected by, you know, subsequent decisions. I have here a decision of the Supreme Court, 2018. We're in 2020 now, just 2 years ago. General Cotton Mills versus Travelers Palace Hotel. General Cotton Mills, 2018 decision, where the Supreme Court, Adamu Augie, by the way, Adamu Augie taught me law at the law school in 87, 88, when I was in law school. Okay. She said, a deemed right of occupancy under section 34, which is what we read now, of the Act, ranks pari passu with the statutory right of occupancy under section 5 of the Act. In other words, the deemed right which the Oba has, as we explained, which the Oba had when he held the land, that deemed right of occupancy ranks pari passu as if somebody else who was granted
the rights to the
by the governor. So it says none is higher than the other. They are both the same. So how can someone then actually say that the Oba lost all his, you know, right? I don't know where that argument is coming from. And okay, let's read another one by Damuage. He says, as I mentioned earlier, statutes do not interfere with legal rights already vested. When something is vested in you, like this land has invested in me, he said the statute will not come and interfere with the vesting of the thing on me now. You can't make a law to take from me what I have. Can you?
No.
No. Why would I agree? He says, and from the decision of this court, that is Supreme Court, in Provost versus Edu, and the provisions of section 34, 1, 2, and 3 of the Land Use Act, it can easily be deduced that the said section 5(2) of the Land Act does not extinguish the right of a landowner who has a deemed right of occupancy. Bam. So the right of occupancy which is deemed is not extinguished. The said rights definitely rank pari passu. Do I need to read more?
No, I think that's okay.
All right, next question.
All right, thank you very much.
I hope the questioner is satisfied with the answer anyway. But if it's not,
of course you can write back.
You can write back and let us know your view.
Let's know your view. Okay. The third question is: you are aware of the Edo High Court's judgment where the court nullified the land allocation documents issued by a community. What is your comment on that?
Well. Judgment that I had earlier read out. My comment on that, obviously, is that this is a matter on which, you know, if I might respectfully say so, the Oba, because a judgment here has, as it were, made a pronouncement divesting His Royal Majesty of his powers over land. A fait accompli. The Oba was not a party. I don't know if you follow me. And the law is you cannot make an order that affects the right of a part of somebody who is not a party to the judgment, to the suit. You know, I mean, you can't just come in and you and no when I have issue. The court decided and say, Dele Igbinedion should do this or cannot do this. I mean, what's it going to do with me? So that's my number one comment on it, that the Oba was not party to it. But to the extent that this pronouncement is serious enough, that it says, the Oba ceased to be custodian of land, and that the Oba of Benin, the powers over land have been taken away, which, respectfully, I do not agree with. And I must say so respectfully, I respect the judge. I've appeared before him. He's a gentleman of very high caliber. But this is his judgment. My opinion is that the Oba, should actually, his attention should be drawn to it so that he can get his lawyers to appeal this judgment. Because, that's number one. Then, number two, it also sort of impinges on the elders of Ohengi and Ikweniro village. The Ohengi and elders of Ikweniro village. These lands, okay, maybe we should clarify that in Benin Kingdom, as in everywhere else, there are three kinds of lands, ownership, land tenure system. You have individual lands, you have family lands, and community lands. So, really and truly, the ones that the Oba had direct superintendentship would have been community land, because he wouldn't come and take your father's house, just like that. So, unless he likes it, and if you give it out, so community land.
Yeah.
So, but these community lands, guess who were in possession of it when the Land Use Act came into effect? The community people. So again, section 34(1) and 2, everybody remained in the position that they were. I think I read it. Yes, as at the time the act came into effect, everybody remained in the position where they were. The act did not take from you what you had. It just changed the nature of the title from, we used to have fee simple, absolute in possession, blah, blah, blah. So it changed it now into statutory right of occupancy. And so, okay, governor can grant land, for use for the public. He can take land for use for the public and pay compensation. So beyond that, there's really no big deal about the Land Use Act, the way people are thinking about it. So I think that this is something that needs to be revisited and to be re-examined, because if you now say that the elders, the head and the elders have no power to transfer land, subject of course to the consent of the Oba, either express or implied, who then, has power to transfer land? You can't say the governor and the local government chairman will not come and transfer my community land to who? All the ones they transferred. And in fact, before we came on, I was reading one case to you where the court said, now having heard that this claimant's father had an equitable interest on the land in question by reason of developments on the land, what is the status of the certificate of occupancy issued by the governor? I can read what the court did now. The court said, in this instant matter, there is no evidence that the right of this claimant over this property was revoked before the certificate of occupancy was issued over the same land. Neither is there any evidence that any compensation was paid to him for his developments on the land. A deemed grant, which is one we have been talking about, a deemed grant, like in the instant case, cannot be revoked by a mere issuance of a certificate of occupancy without more. And don't forget, we had said that the Oba also has a deemed grant over lands in Benin Kingdom. So the deemed grant of the Oba cannot be revoked by issuing somebody a certificate of occupancy. You must first revoke, the Oba's interest. Having not expressly revoked the interest of the claimant on this land, the governor had no power to issue the certificate of occupancy over the same land. Consequently, certificate of occupancy number, blah, 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 I will not mention it, dated, blah, 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 stands revoked. And it is hereby revoked. The court revoked it. And that was the end. Ogbua.
Alright.
That's how the court killed it too. So, certificate of occupancies are revocable if you go and get it without consent of the people on the land. So if you get from the people of the land, I still say it, if you do not have a legal title, you have what is called equitable interest. And that equitable interest ranks high. Higher than even a certificate of occupancy.
I believe the Land Use Act also states that before you obtain a certificate of occupancy, you must satisfy the governor that you are actually the owner of that land.
Exactly.
So it means prior title or title to the land is a necessity to obtain that certificate of occupancy.
But what some people don't want is they don't want to go to the people on the land to buy. They just feel okay, like in this case that we cited. If you read the facts, somebody just knew a governor because they were pally-pallies, they were political, friends. Governor just gave him another person's land, gave him a CFO and said, go there and build a hotel on it.
Are you serious? Without revoking the ownership?
Without even, going, minding the people on the land. So, but the court revoked it because the certificate of occupancy is revoked.
Simple.
So, you cannot get a certificate of occupancy without the elders and the people in the land. You cannot get, if you go and get, you have a worthless piece of paper. Not worth the ink that is written on. So,
all right, thank you.
All right, so
how
many questions have we taken so far?
We've taken
3 questions. Can we just take a short break and then probably we just come back after a short break? If you have not subscribed to this YouTube channel, please, you need to subscribe. Click the subscribe button. And the
notification bell.
Notification bell, so that anytime we post videos, you can get it. Then, if you like the show, what should they do? Give us a thumbs up, okay? It's important. YouTube actually counts thumbs up, so don't say, well, it's not important. It's important, okay? And if you don't like it, you can also give us a thumbs down.
I actually prefer the thumbs up, actually.
Don't prefer the thumbs up, but okay, let everybody know they are right. All right, so we'll just be right back, and then we'll continue with the next question coming from Josephina Ogaga Warrior. All right, welcome back. So we stopped at the 3rd question. Any more questions, or am I free to go?
Oh, you're not free to go, believe me. We have other questions from interested viewers.
Okay.
Okay, question number 4.
Yeah.
It says, are you seriously saying that the vesting of all communal land in Benin on the Oba survived the Land Use Act of 1978? Are you seriously saying that?
Good question. Yes, I'm saying it survived it. It remains till today. And I say it with all due respect, because I'm sure there will be people's opinions on different sides of the divide. But if you disagree with me on the point of the law. Okay? And by section 34, 1 and 2, and various decisions of the Supreme Court, there is nowhere that the Oba's interest, the Oba's legal title to the land was terminated by the Land Use Act. In fact, the Land Use Act preserved it. In fact, let's read it. Maybe we can read section 34. Okay, for those who, because I like it when I read law. It just makes me excited. All right, sorry about it. Okay, section 34(2). Listen. Those who will disagree, listen very well. Where the land is developed, the land shall continue to be held by the Oba in whom it was vested immediately before the commencement of this act, as if the Oba was the holder of a statutory right of occupancy issued by the governor. It doesn't say where the land is developed, the governor can now give, give the person. No. It says it shall continue. When you talk about continue, if I tell you now, continue, does it not mean you have been doing the thing before?
Of course.
If I say continue eating, it means you have been eating. I can't just give you a cup of water. You just come in and say, Josephine, welcome. Take a cup of water. Continue drinking. I mean, it's not going to make sense. It's not going to make sense. But if you were drinking before, maybe it was half full, and you're taking that, and you want to top it up, and I just add, I say, okay, continue. That makes sense because you were already drinking it before. Yeah. Or rather, you should give me water because I think you. Okay, so, but the point being that when the law says the land shall continue to be held by the person, it means the person was already holding it. So my argument, my postulation, my humble submission is that since the land was vested in the Oba before the Land Use Act came into effect, the Oba continues to hold it. Continues. It's a continuum. It's an unbroken chain. It's not a beginning. It's a continuum. Nothing happened apart from the slight interruption that was brought in by the Land Use Act. So for those who say the Obas cease to be custodian, why does the law say it cease to be? If the law wants to say all those who held land cease to hold it, he will say so. He will simply say so. So why does it say they cease to hold it? You are telling me now that land which I bought in 1976, yeah? Land which I bought in 1976, as the Land Use Act just came in, he took the land from me. I mean, for goodness sake. So, in your village, Owen, the land which people have been farming on, the families, they are no longer farming on. It's the governor that is farming there now. No. So, where is the interpretation? Where is the interpretation? You only look. It's just like, you know. Let's face it. If I buy a car now, and I've already bought the car, it's my car. I want official documents for the car so that if road safety stops me on the road or police, I have license and all that to show them. I go to the government to give me vehicle license. It does not mean that my vehicle now becomes the property of the government. It's still mine. They give me my vehicle license for official documentation purposes. Because I can be driving a car that government does not know. You are driving one. Owen is driving one. Everybody just driving car. Government doesn't. So they say, look, we have to register all vehicles. The same thing with land. They register all lands. But when my vehicle paper expire, does it mean the vehicle now belong to government? If I say, okay, I will not renew my vehicle again. I'm driving it. I don't have paper. Police hold me if you want to. So when they stop me now, they say, your vehicle paper expired. The vehicle belongs to government. No, absolutely not. So that's what I'm saying. That I'm seriously saying it. I'm seriously saying it. That the vesting of communal land in Benin on the Oba survived the Land Use Act 1978. Yakanku. That's what I'm saying. All
right, thank you very much. I hope that viewer is satisfied with that answer. Then I'll read another question. It says, will an approval granted by the Oba today be valid in law?
Very valid. Very, very valid. Because there was nothing that said Oba don't grant approval anymore. I know that in practice, since 1978, for some reason, the Oba stopped granting approvals. I don't know why, but I think that's what happens in practice. But I am saying that if there was to be an approval granted by the Oba today or yesterday or tomorrow, it will be valid in law because the land is still vested in him. Now, let me just make one point. The argument of certain people is that the Oba ceased to be the custodian of land, so he couldn't grant approvals. The communities can't grant, families can't grant, individuals can't grant. Abi? Yeah. Okay. But if you go to the governor for a certificate of occupancy, is he just going to just walk and shake his hand and say, Your Excellency, I want, okay, Commissioner for Land, I want certificate. You say, where is the land? Oh, that land that is beside the so primary school on the right. Okay, that land. Oh, registrar, give him certificate. Is that how they do it? They must still ask you, where is your documents of title? They must ask you. And which one are people giving them now? The community document. They say community document or the transfer from Dele Igbinedion to you or the transfer from Igbinedion family to you. It's what you also present. So if the government can recognize it for purpose of doing C of O, how can we then say that the community don't have power? It's just, for me, a question of perhaps we need to do a little bit of a seminar on this so that we can all harmonize our different thinking, our thoughts on this. You know, but right now, I feel that the only, the only person being cheated in this whole thing is who?
The Oba.
The Oba. He's the one being cheated in this whole thing. Now, I'm not his lawyer, so that somebody will not, oh, he's a lawyer now. No. Okay, I've never met, the gentleman, but I hear he's a great fellow. I watched him on TV where he was doing, what do you call this? What do you call that?
Dance.
Yeah, what do you call that one now?
The normal regular dance.
Shaku. Yeah. If you try him, you will lose. Forget.
I've not watched that.
Yeah, forget. During what children's occasion.
Wow, that's nice.
Wonderful.
All right.
Yes.
Okay. We'll take another question. What is the?
You're not the last. Okay. Okay,
no,
go
that's
on.
not the last
Okay.
question, actually.
All right.
So, what is the proper procedure for acquiring land in Benin Kingdom as at 2020?
The proper procedure for acquiring land
A
is
legal title now. We're talking about
legal
not
title.
Equitable title. Like, what is the proper procedure, in your own opinion, for acquiring land?
well, the
Or according to the law?
courts have established it in Joku and Emenike. Number one, you go and pay the purchase price of the land
Price?
and have yourself put into possession by the landowner in the presence of witnesses.
Okay.
Then, if it's common, that's if it's individual land. If it's community-owned land, you pay the requirements of the community.
Okay.
Then they give you the document. Are you with me now? Then you go to the Oba. And then go and apply for a legal title from the state government to give you a certificate of occupancy.
Even individual lands.
Even individual lands, you still need a certificate of occupancy from
And you
the
still need
government.
approval from the Oba.
Sorry?
You still need approval from the Oba.
You will not need approval if it's personally owned land. Because it is your land. But if it's communal land, because again, like you earlier asked a question, I don't know if you have a question, there's some, custom and tradition sort of gravitates along with decisions of courts. Because the one I'm reading here, Nanjoku and Emenike, the Supreme Court said to constitute a valid sale of land under customary law. These are the ingredients. 1, payment of purchase price. 2, purchaser is let into possession by the vendor. 3, in the presence of witnesses. He said that is valid. But that's personal land.
Okay.
Personal land. But if it is community-owned land, that is where the Oba's interest, really and truly superintends.
Okay. I want to ask a question.
Yeah.
What about community-owned land that was previously allocated to someone? Does that make it personal land or is still community land?
Community-owned land that was previously.
That was allocated to someone. Let's say the Oba granted approval to someone to own that land or use that land.
Before or after Land Use Act, if the Oba grants approval to somebody, it becomes personal land now.
It becomes personal
It
land.
becomes personal
so
land.
it means if you are purchasing from that person, you do not need to obtain the Oba's consent.
You don't need the Oba's consent again because the Oba's consent was given before from your scenario. But if it is community land, so the distinction is it personal land, is it family land, is it community land? The authorities are to the effect that for community land, for family land, the procedure is different. You need the head of the family and the family members. For individual land that I own, I'm the one to transfer. For community land, the land we all own together. I can't do it. We have our Enogie or Jonwere or the Ohen or whatever, who with the elders can transfer. They can transfer because they have an overlord who is the Oba. So they go to the Oba. This is to get legal title. If the Oba has not approved, what you have is equitable interest.
Okay. That's it.
That's it. Simple enough.
All right. So I believe you understand the procedure now of obtaining land or acquiring land in Benin as at today, or in Edo State rather, as at today. So if you want to buy land, make sure you go through the right process. Okay, another question. What is the legal status of community approvals?
The legal status of community approvals, to my mind, is that it gives you an equitable interest, because it is not the final document that you need.
Okay.
It doesn't give you a legal title, but it gives you an equitable title. Now, the document with possession, and you know, possession is what? 9/10 of ownership.
Ownership, yes.
9/10 of ownership is possession. I have been on the land, I'm farming on the land. Who is going to drive me out? Okay? So, but for someone to come and argue, oh, you don't have legal interest. To get legal interest, you go through the His Royal Majesty, you go through the government to give you a certificate of occupancy, then you have a legal title. But if you have not done that, but the community have given you document, you have equitable title, particularly where either you are in possession or you have developed the land. And you know that Supreme Court has held development means as long as there's a road, you put a block, you put cassava, anything is development. So the status of this community allocation document is that it gives the holder at least an equitable title over the land.
And we're saying that this, you stated earlier in your illustrations that this equitable title ranks high above the certificate of occupancy. You said that.
It ranks high above the certificate of occupancy brought by any other person
who doesn't have title.
Who has no title to the land.
Okay, I think I get that. And I believe that's the last question we'll be taking for today. So you can send in more questions. Whatever your opinion is, you can drop suggestions, questions, and commentaries on today's show. All right.
Thank you. I think that's all we can take today. I hope you've benefited something. So keep your comments coming, like she said, and do give us a like, a thumbs up, and subscribe if you've not already done so. Bye-bye. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. 24 hours, 7 days a week.
For more exciting, educative, and entertaining programs such as Law and You, Talk Politics, Entertainment Gist, Relationship Talk, Top 5 Gems, and other programs, keep watching Pinnacle TV. You can watch live and subscribe to our YouTube channel at Pinnacle TV Online. You can also visit our website at www.pinnacletv.com. Follow us on Facebook at Pinnacle TV Online or call us on 081 546 99989. Pinnacle TV, top quality broadcasting.